Good morning, viewers. Welcome to Consumer Shorthand classes. Get ready. 5 seconds. Start. Whether the punishment is an outrageous defiance of logic, reason must be given. It is difficult to say when the punishment is shockingly disproportionate. Courts should not encourage indiscipline. Misconduct should not be underplayed. Imposing such a punishment to a workman will lead to further deterioration of discipline. Where the workers resort to strike in sympathy of suspended workmen, Section 11A should not be invoked. Misconducts are on the increase, ransacking the congenial atmosphere at workplaces, muzzlemen dictating terms to the management, thereby creating unrest. In such cases, Section 11A shall not be invoked. The survival of hotels or hospitals, industries is on customer satisfaction. Any indiscipline will affect its business. In such cases, Section 11A should not be invoked. Unblemished long service is no ground to interfere with the punishment of dismissal, even though the misconduct may be of the first time. Compensation can be ordered. Section 11A is not meant to be equated to charity. Poverty is no ground to interfere with punishment. Where service conditions are governed by a set of rules, Section 11A cannot be invoked. It is not the value of the property, but theft being a heinous offense. Section 11A cannot be invoked. Powers under Section 11A can be exercised only in the cases of dismissal bar termination. Labor court cannot interfere with the punishment without giving adequate reasons. Labor court, while exercising powers under Section 11A, cannot pass an order on meaningless reason. Justifiable reasons must be given. Enquiries are not to be mechanically set aside unless there are inherent enquiry basic defects, infirmities, and illegalities. It is well settled that a conclusion or a finding of a fact arrived at in a disciplinary inquiry can be interfered with by court only when there is a fact for the said conclusion, or that on the material the conclusion cannot be that of a reasonable man. Where the domestic inquiry is a valid one, it cannot be interfered with by the appellate court.